Hello, truth seekers. I would like to begin this rather impromptu video done on poor recording equipment to tell you the odyssey of Austin Steinbart has taken many twists and turns, but it continues. Looking at this tweet by Magic Mad, it covers the topic for today's discussion. This individual says, "I'm not defending Austin. I am questioning the DOJ's tactic of imprisoning people without charging them. This is the USA. We have unwavering constitutional protections that are clearly being violated here, while you cheerlead the efforts to erode our rights. Who is the D-Rider?" So in previous videos, I covered this character here, Austin Steinbart. I covered many proofs possibly linking him with the Q board. For the purpose of this video, I'd like to discuss his rather dire situation. Today he's had a hearing that was done as a follow-up to an arrest which occurred on September 1st. Here is the document which was used as a petition for Austin's reapprehension. Specifically, this is under pretrial services. Austin, according to this document, had committed a violation of his pretrial services by intaking marijuana between 10 to 20 times. He admitted that to the officer. So for violating his pretrial services agreement, the judge basically took away his freedom and decided to detain him until his trial. As those following Austin's situation are aware, he was basically arrested by the federal government with a charge complaint of extorting the company Dado for a product that they held of Austin's called the Amorphous Archive. When you get a charge complaint, it is supposed to become a charge indictment. And once the indictment occurs, it is essentially a charging document that is read to the person arrested. When that occurs, you have something called an arraignment. So here in Wikipedia, it defines arraignment as a formal reading of the criminal charging document in the presence of the defendant to inform him of the charges against the defendant. In response to the arraignment, the accused is expected to enter a plea. So Austin recently admitted guilt to using marijuana while he was on a pretrial services agreement. That is not the same thing as this. Austin is to plead guilty or not guilty to extorting Dado. However, this special occasion called the arraignment has not occurred. Austin has been in a pretrial state due to the viral pandemic at this point for 180 days. You should know that it is the Sixth Amendment to the United States Constitution that guarantees a criminal defendant the right to a speedy trial by an impartial jury. Over 180 days to get Austin before a jury at this point is by no means speedy. So I'm lucky enough to get into a press corps where there's a specific press release I am to convey. So yes, I'll remind you that the purpose of the content I've placed on my YouTube channel is to analyze the claims of Austin Steinbart to see if he is indeed Q. In this instance, I'm going to convey some press material that Austin would like to have go out, really in defense of his name. I feel comfortable defending Austin in this context because I've taken a look at the material and I agree with it in general. So I think a way to convey this would be to look at this particular tweet by Jake Rotchetnatansky. Breaking: Austin Steinbart's pretrial release was revoked because he smoked marijuana 10 to 20 times and then tried to pass his drug test with this, and it shows a picture of a Whizzinator. So this particular tweet is very biased, and the purpose of the press release would be basically to correct misconceptions that one would get from looking at a tweet like this. Basically, Austin had his pretrial release revoked, in his words, in Austin's words, not because of this specific issue of him doing the marijuana, but because one of his enemies had conveyed to his appointed pretrial services officer a video of Austin with an apparent alcoholic beverage, specifically described as a cider. The officer just seeing the picture of Austin with a cider was enough to get the pretrial release revoked, in Austin's words. Austin never made it to an actual drug test to see if he done marijuana. I have to be very careful how I state this. Another portion of the press release states that Austin's pretrial services officer supposedly lied or may have simply misspoken, saying that Austin was being dishonest on the subject of actually doing marijuana, when Austin, in his own defense, said actually he specifically told the officer he did marijuana 17 times. At this point, what happened with the pretrial services officer and the perception of Austin's honesty, this would be considered an allegation by Austin on the pretrial services officer. In the court hearing which occurred today, Austin had an interaction with the judge where he seemed to, in like a pro se manner, argue his case with the judge, almost as if the judge was an attorney. It was a very interesting exchange. Austin was stating in this exchange that he has celiac disease and that he needed the marijuana to feel better from abdominal pain caused by the condition. Later in the hearing, his own mother also spoke on Austin's behalf, stating that he has had problems with abdominal pain since being a child, and this pain would occur whenever Austin would accidentally consume gluten-containing foods. Austin had had a somewhat rough time in prison, or I'll just say in jail, because the food offered was often potentially contaminated with gluten. As a way to adapt to the circumstances, Austin Steinbart would basically eat shredded meat and nothing else. He viewed his use of marijuana as a type of medical treatment and found the specific federal court restriction of the drug somewhat overly deprivational. I can tell you from my vantage point, it appears to be in anticipation that Austin could be in jail for a long time without a charging indictment, which does appear to violate the Sixth Amendment of the Constitution. In In court, the judge appeared to defend this constitutional violation by alluding to the fact that there are other defendants who are in similar circumstances, somehow making it right. Very clearly, Austin's circumstance could be seen as being akin to Julian Assange, though in this case it's a bit worse than Assange, as Assange actually has an indictment, unlike Austin Steinbart. Lastly, I have to say that Austin wanted to convey the message: the show must go on. Even though Austin is going to be away for an indefinite period of time, it is his desire that specific points of his plan be implemented. Specifically, apparently, Austin wants the amorphous archive to be completely made plain to the public. Austin Steinbart wants you to know that he plans to continue to fight until the very end, that the next 2 months are going to be very eventful, and that, yes, he even intends to manage a fight against his opposition even while imprisoned. His opposition is the nihilistic, satanic NWO control grid. He uses a term D6 to describe some of the interlopers of our civilization. You'll hear more about D6 and the Amorphous Archive from his major press group, his Q team, in the coming weeks, I presume. Yeah, say what you want about this Austin Steinbart character. You have to acknowledge that if he goes to the lengths of putting out press releases on the day a significant motion is placed against him in terms of his freedom, he is an individual that doesn't lay down. He will fight and fight. Potentially, I may be able to provide you some additional Q intel on Austin's fighting spirit, depending on the strength of my contacts and sources. Anyhow, I apologize. This video is poorly edited and recorded with poor equipment, but it is just the specific circumstance I am in now. I just simply need to get this press release out. Take care. Bye.